Welcome to Employment Law This Week. I'm George Whipple. Our top story, a Supreme Court ruling confirms limits on presidential appointment powers. Lafe Solomon served as NLRB Acting General Counsel under President Obama for 3 years, 2 of which while his nomination for a full term was pending in the Senate. The court found that, under the Federal Vacancies Reform Act, he could not serve as acting GC while his nomination was pending. This ruling will restrict President Trump and future presidents' power to temporarily appoint their preferred candidates to the approximately 1,200 positions that require Senate confirmation. Mark Trapp has more.
The court ruled 6-2, upholding a decision of the District of Columbia Circuit Court of Appeals that the Federal Vacancy Reform Act prohibited a person from serving as the acting head of a federal agency once the president nominated that same person to serve as the permanent head of that agency. Thus, in this case, President Obama exceeded his authority when he directed Lafe Solomon, a career NLRB attorney, to serve as the Acting General Counsel of that agency, and subsequently nominated Mr. Solomon to fill that post permanently. In the sense of a retroactive impact, it's probably quite narrow.
The Fair Pay and Safe Workplaces rule is no more. Last Monday, President Trump signed a Congressional Review Act resolution from the House rolling back the controversial Obama administration order. In October 2016, a federal judge blocked the government from enforcing most of the rule, including restrictions on arbitration agreements and the so-called blacklisting requirement. That provision would have required certain federal contractors to disclose labor law violations from the prior 3 years. But the president's action scraps the rule entirely, including the requirements that contractors give workers detailed pay information each pay period. DOL Secretary Nominee says the overtime rule could use an update. Alexander Acosta has indicated that if confirmed for Labor Secretary, he would consider updating the salary thresholds for overtime to reflect inflation. During confirmation hearings, Acosta said that he would first decide whether to continue the department's appeal of the federal injunction on the overtime pay rule. He noted that it is unfortunate that the thresholds have not been updated since 2004, but the $47,476 salary level that the Obama administration tried to implement would create a stress on the system. Disabled employees who request reassignment as a reasonable accommodation can be required to compete for a vacant position. That's according to a federal court in Texas. The EEOC argued that a Dallas hospital could not require an employee to compete with non-disabled candidates for a vacant position when she requested reassignment after injury. The court disagreed. The Fifth Circuit has never directly addressed this issue, but there is currently a split among the circuits. And that brings us to our tip of the week. Mark Schubach, former Senior Vice President, General Counsel, and Secretary of Aeropostale, is here with some advice on best practices for documenting poor performance in the workplace.
Proper documentation of poor performance will make the removal of a poor performing employee as seamless as possible. Communicate the importance of documentation. Supervisors and managers who understand the importance of documentation will be more likely to follow the documentation policies and procedures. Train supervisors and managers on documentation practices. Training should be provided in written form. Don't be afraid to involve the HR and legal departments when performance issues arise.
Thanks, Mark. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.